door knocked here up front. Okay, great.
We are live.
Okay, the chair calls to order the June 26th meeting of the Kansas Governmental Ethics Commission. Welcome, commissioners and staff. In your materials today, you have the agenda and the materials. Can anyone identify any corrections that need to be made to either? If not, I will take a motion to approve so we can begin.
I moved to approve the minutes.
I second.
Motion has been seconded. Any additional discussion? All in favor of approving the motion to approve the agenda and minutes as written, signify by saying aye.
Aye.
All opposed, say nay. The motion passes. Turning to the agenda, we have the introduction of a new commissioner.
My name's Samuel Clausen. Good to be here.
Yeah,
Welcome.
Nick, if we want to, we could, I know we've done this quite a few times in the last several meetings, so apologies.
Yeah.
But we could do a very quick once around the table, just so at least, I know name tags are not always easily visible across the table, so we can at least do a quick once around for names.
Yeah, I will begin just on my end, and then we can go to Andrew, and then we can do everyone there in the room. But Samuel, my name is Nick Hale. I've been the chairman on this commission for the past 5 years. I'm a in-house counsel for companies that deal in brewing and importing in Kansas City. I'm from Wichita originally, and I currently live in Fairway. Andrew?
Yeah, so hi, I'm Andrew Harrison. I'm a law student at KU right now, and I was appointed, let's see, it's been a while, last January, I think. So glad you're here, and thank you.
Boys. Yeah, no, we're at the same time. Samuel, he's Jerry Homer. I'm from Salina, and I may be one of the most senior members of the at this point in time. However, we've got a lot of changing faces, and I'm alleged retired village. Welcome aboard. And do you want to go?
Sure.
Real quick.
I'm Caitlin Bull Stewart. I'm the general counsel. I have been general counsel here for a year last week, so it's nice to have you on board.
Mark, we've met. You know, I am the director.
Brax Stevens and Brand. Thanks, Steve.
Guys from Tony, you know me too. Tess Ramirez, I'm an attorney. And last meeting was my first meeting, so.
All right.
My name's Earl Glenn. I started here in March, so I'm pretty new too. I'm a retired number cruncher researcher.
Hey, Bo Jackson. I work at Hush Blackwell in Kansas City, originally from the Wichita area, like the chairman. And I just joined in February or March as well. One of the many newbies.
We're gonna put you all together.
Put us in order.
Right.
Yeah, we
The
do have
longer the better chair you get. It's
Yeah,
just,
the certain seniority perk.
Jesse Burris, conflict counsel, Attorney General's office, and last meeting is my first meeting. So,
So sorry.
Welcome to it.
it was my first meeting.
it happens to be the case right now. It's been pretty difficult.
Yeah, well,
It's kind of the case.
It's been a little odd. Yeah, normally reappointments happen in January. I know your seat, someone had resigned. We've had, say, situations where someone thought they could do it for a while, then didn't. We've just had a few instances this year where that just happened to come up. And typically people serve until their terms, they serve until they are either reappointed or replaced, which means that even though their term technically ends in January, it's fairly typical for someone's term to last an extra couple months after that, even if they were ultimately replaced.
Okay.
So not entirely outside of the norm, even though this is a little late normally, but not a problem at all. So.
Well, welcome again, Samuel. Turning back to the agenda, I see that you have on there that we would begin with an executive session. Do you want to frame this up in any way, Director Skoglo?
5 minutes. I mean, it'll be very, very brief, I think.
Okay.
I think 10.
You think 10?
Just out of an abundance of if there are
Alright.
questions.
What if the motion passes? Yes.
Okay. If somebody conveniently has the motions that were provided in your materials, I will certainly take a volunteer for somebody to read the executive session or just the executive session motion.
That's the one
I'm
with staff.
I'm looking for it.
Yes. Because this is,
Well, I was, but
Here it is.
oh, you know what? Oh, okay, I did that. That's easier than.
just,
You've got the right one.
In 10 minutes, so we're supposed to say,
1:15.
Okay, I move that the commission recess this open meeting with the executive director, Mark Scoglin, the office manager, Paige Quintana Paget, the general counsel, Caitlin Bull Stewart, and conflict counsel, Jesse Burris, present to discuss matters related to confidential investigations pursuant to KSA 25-4165 and KSA 25-4161, and for good cause as provided by KAR 1962. Justification for recess is so that the
This is
commission.
not the right motion.
It's confidential.
I have the
Oh,
right
this
motion.
is recess session one.
Yep. This is the right motion.
Here's the other one.
This was.
Save that for later. Okay. So,
sorry,
sorry.
we've got lots of these today.
I don't know. We're doing the first one.
This is an executive session. We added.
That's for litigation discussion.
Sorry.
Okay,
Sorry about that.
that's all right.
Let's start
Sorry.
clean slate.
I move that the commission recess this open meeting to executive session with office manager Paige Quintana Paget, executive director Mark Scoglin, general counsel Caitlin Bull Stewart, and conflict counsel Jesse Burris present to discuss matters related to potential federal court litigation and for good cause as provided by KAR 1962. Justification for executive session is so the commission can consult with its attorney regarding matters that would be deemed privileged in the attorney-client relationship as contemplated by KSA 75-439-1B2. The open meeting shall be resumed here at 1:17.
Yes. All right, do I have a second?
Second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to enter into executive session signify by saying aye.
Aye.
All
Aye.
opposed say nay. The motion passes.
Yeah, it's pretty rare.
It's not like him to miss, is it?
These early, in fact.
Okay.
All right, we
Are we
are
good?
good to go.
Okay. Returning to the agenda, the next item is an advisory opinion, 2024-2. Caitlin, do you want to speak to this?
Yes, so this is the advisory opinion that at the last meeting I'd requested a bit more time to work on. This advisory opinion deals with Chapter 46, which we haven't discussed a ton at length yet in my tenure here, but it is relating to the registration of a lobbyist. And Mr. Kozine, who submitted the request, was specifically asking about a nonprofit group called EdChoice. And he had 3 very specific questions in his email, which is attached to the advisory opinion. He asked if EdChoice exceeded the $1,000 registration threshold within 46-222A3, if they must register as a lobbyist, even if the legislature is not in session when they cross that expenditure threshold. He asked if it is required to register as a lobbyist any differently, being a nonprofit organization as opposed to an individual, and also asked if EdChoice could pay for travel for Kansas legislators to attend an annual educational program that EdChoice puts on. For a little bit of background into EdChoice, there's only a few things that we've recited in the facts here. It's a 501, it's a nonprofit organization and hosts this annual program that it calls its educational program. They allow for legislators that attend to engage in the program and discuss educational choice policy. So that's things, such as voucher programs to choose private schools. And they want to pay for legislators to attend the program. That would include covering travel, lodging, food, and beverage. For context in the lobbying statutes, 46-222 lists 4 different actions that would render a person a lobbyist under Kansas law and require them to register with the Secretary of State and then be regulated by our office. One of those definitions, which Mr. Kozine was specifically asking about, is subsection A3, which states that a lobbyist includes any person who makes expenditures in an aggregate amount of $1,000 or more, exclusive of personal expenses in a calendar year for lobbying. A person is defined within Chapter 46 to include a nonprofit organization or a corporation, and KSA 46-265 requires those that are considered lobbyists under 46-222 to register with the Secretary of State. The test within 46-222, this was a fairly straightforward answer. It is indifferent to whether or not the legislature is in session. The question is only whether the $1,000 expense threshold is exceeded. That's all that portion of the statute cares about. If it is exceeded, then they must register as a lobbyist. Additionally, regarding his second question about kind of the administrative side of things, of if a nonprofit registers in a lobbyist differently than an individual or a regular corporation, the answer is no. They do not register any differently than any other person under Chapter 46. The entity itself is considered a lobbyist. They select a representative because, again, it's an artificial entity. They have a representative that registers as a lobbyist. And then they are listed on the lobbying registration forms, EdChoice itself, rather, as the person compensating the lobbyist for lobbying. Finally, the last question is where the exception that they're asking about within the gift prohibition is very narrow. For context, Chapter 46 really is the governmental ethics laws, and KSA 46-237 is the general gift prohibition that applies to legislators. And generally, gifts are prohibited unless they fit an exception that is outlined within the statute. Mr. Kozine was specifically asking about an exception that is found at 46-237 sub H, which I have included as a block quote in the opinion. That is a very narrow exception, and the commission has interpreted it narrowly in the past through former advisory opinions, one of which I mentioned in this current draft of the opinion as well. This narrow exception requires two things. Their organization to give a gift to a legislator and not be in violation of the statute has to be a national nonprofit, nonpartisan organization, and it must be established for the purposes of serving, informing, educating, and strengthening state legislatures in all states. The commission has interpreted this narrowly in the past. As I mentioned, advisory opinion 2012-09, this question came up, and it was about the Foundation for Government Accountability that was trying to do a similar type of program. They were trying to, or not a program, but trying to also fit under that exception. The commission found that they did not fit under that narrow exception because they were not established for all four of those purposes that are in the second part of the test. So the second part of the test, not only is it national, which based on some review of EdChoice, it appears that it is likely a national nonprofit organization based on what Mr. Kozine had said to us, that they reach out to most legislatures in most states. It likely meets the first requirement, but I chose to couch that language into likely because I didn't delve super deeply into everything that they do. But the second requirement of the exception, they do not fit under, which means this is an element test. So they have to fit both aspects of the exception in order to use it. It does not appear that EdChoice was established to serve, inform, educate, and strengthen legislatures in all states. In fact, if you review their website, the focus of EdChoice is school choice advocacy. They are engaging in policy advocacy. While they may be doing some educating, they were not established to serve, inform, educate, and strengthen legislatures in all states. The specific and narrow language by the commission in the past, or has been found to be specific and narrow in the past. And because EdChoice doesn't check off all those boxes, they cannot use that exception. However, as I mentioned before, gifts are prohibited unless there is an exception. And they were not just EdChoice is not just asking to pay for travel, but they were also asking to pay for food and beverage for legislators that attended their annual program. And that would be acceptable under the exception in 46-237D, which says that food and beverage is presumed not to be given to influence a legislator. So as long as there is no official course of action conditioned on the giving of the food and beverage, that would fall under a different exception, but would be lawful under Chapter 46. So I know I kind of talked through a lot. I'm happy to entertain any and all questions and changes.
Guess I have a couple
Sure,
questions.
yeah.
Because I researched IRS 990 a little bit too much.
No, you're fine.
The 2021 IRS 990 for this group says that they work at the state level to educate diverse audiences on the benefits of high quality school choice programs. So operating at the state level, they have to say specifically that they're going to educate legislators? Is that what you're looking for there?
No, it's that it has to be. So part of the distinction there is when a group is engaging in advocacy, that is not meant to serve, inform, educate, and strengthen legislatures.
So what does strengthen mean?
Yeah, so these are really out there for groups like the National Conference on State Legislatures, NCSL. There's also the CSG, which is the Something for State Governments, Council for State Governments, maybe. Organizations like that that are about serving and strengthening state legislatures. It's clear when the legislature had that language in the statute that it was not merely meant that any organization that asserts that they're an educational organization can just generically meet under this very large exception otherwise. So they added serve and strengthen to that list of 4.
Because then in the 2022, well, and actually their other name, it's hard to get these 990s because the IRS is late. So I can only get the 2021 from IRS. ProPublica, which is a reliable enough source, they actually said this group's name is the Milton and Rose Friedman Foundation. Milton Friedman was a Nobel-winning economist, so he has a national scope.
Mm-hmm.
And then in that 990, it says here in part, well, they spent $3.4 million in that particular year, testifying in front of various legislative bodies, sponsoring and hosting informational symposiums, and educating local and state organizations. But that's still not specific enough that it doesn't say legislature. Is that what you're looking for there?
It's not what it says, it's what they're doing. So they're engaging in policy advocacy. They're not just trying to educate, or some of the examples what they do is discuss like rules of procedure, how you set up committees. It's more of how a legislature functions rather than the policies the legislature should be enacting.
I get your, but so you're saying the law is that latter one, which is just the function of the legislature, not.
Yes, the commission has interpreted it very narrowly before, and the way that the statute is drafted uses the word "and," which means that all 4 things must be met before that exception can apply. So it must serve, inform, educate, and strengthen all legislatures.
So if they're only policy in one area, you're saying that disqualifies.
Correct. Yes.
And the way that it's written as well, I know Caitlin focused on this a bit, it's also the reason it was established is part of the catch-all or why this exception exists. So groups like NCSL and CSG, they were established theoretically to serve state legislatures or their legislatures. So if that's really, we're trying to be very textual here and just be limited to what the text says without going too far beyond what was requested. Which we never really want to do.
Have there been any other advisory opinions? See the 2012-09 one, Foundation for Government Accountability. Do you know if there's been any others on this interpreting this statute?
That's the one that we most commonly refer to. Offhand, I don't know if we have others. That's the one that comes up the most because the Foundation for Government Accountability essentially asked very similarly here, do we fit under this statute or do we fit under this exception? And the commission at the time said there are 2 that, number one, at the time, the group was focused on Florida, so they were not a national organization, but they also had an aside comment that in the next paragraph where they were commenting about the serve, strengthen, educate, and inform, they said they also would not meet that criteria as well. This case is a little different because I think that it's Caitlin's interpretation here, and I wouldn't disagree with it at all, that it is a it fits the definition of a national nonprofit and is nonpartisan as well, which means that it would meet that first tier,
Right.
which the Foundation for Government Accountability did not.
Didn't even meet that one. Yeah.
Mhm.
Right, but here, it's the same problem as the Foundation for Government Accountability. It was established for other purposes than serving and strengthening legislatures.
Got it. And then my other question, more of a pragmatic or practical one, Caitlin.
Sure.
So they want reimbursement for all travel, lodging, food and beverage.
Mhm.
And what you're saying kind of in the conclusion is you're not going to get that because you don't meet the exception in H, but you might meet D, therefore you could get food and beverage.
Yes, that's correct.
So the practical concern is we can't authorize everything, but we would authorize.
Yes. Yeah, absolutely.
All right, thanks. Those are my
Mhm.
questions.
So what is the process? I mean, I view these letter opinions as being a declaration really of law as we interpret it as a commission. But this seems to be really focused on the factual side about this organization and what it intended to do when it was originally formed, which is a new kind of development to me. But how do we as a commission, when they submit something to us, which obviously is their own opinion, and we're gonna make a factual finding? No, if they're gonna submit something to us, do we have to accept what they say? If we don't accept what they say, what power do we have to independently investigate it and then come to a factual conclusion without their input or involvement?
We have had circumstances where we've asked them for additional information. We've had instances where the commission has simply said, these are the facts. You would have to serve, strengthen, educate, and inform in order to meet this. We don't think you provide enough information to.
So there sounds like the legal opinion, though, is what does it mean to serve, strengthen, yada, yada, yada.
Sure.
And then we can lay out what we interpret that to be. And then each of the different entities, whatever they may be, will have to self-evaluate.
Yeah.
Because I'm not comfortable ignoring what they present to us and reading into it, whether it be a tax document or research or something of that nature. When we're going to make a declaration, a finding as a matter of fact that simply says, I'm sorry, but you don't apply. If we want to limit it to a limit, if we're going to expand it to a legal declaration of what we think these provisions mean and how they might apply to entities, I'd be more comfortable with that.
Typically, I mean, this is kind of the role of the formal opinion process, is essentially someone is saying, this is the activity I would like to engage in. Would it be okay for us to engage in that activity? And this is an opinion that
I
says.
don't think we can ever say whether a particular person can or can't.
That's how our statute's drafted, though, is that the formal opinion creates a safe harbor for the individual requesting the opinion and their specific facts.
Yeah. So if we said, yes, this is legal, and later on in district court said, well, we don't think that the commission was right, it didn't matter because they had the safe harbor provided by the opinion.
So if we find against it, it would not be a safe harbor.
Correct.
Yeah. But if we found for them, then they would be free to fit their activity under 237H if we said you do fit under 237H, and no court otherwise could find differently because by statutorily they have that safe harbor provision, and that's why it's formal opinions are about usually specific scenarios that deal with people. We do sometimes have all interested persons opinions that are more general. That's like, for example, our childcare opinion that said when you can and can't use campaign funds for provision of childcare. That was a broad opinion talking about the law. It was not specific to one person's scenario that they were dealing with. We said this is the state of the law, and either one is fine. They're both permissible opinions that the commission can issue.
So in this situation, this individual is requesting guidance from the Ethics Commission. And is there an expectation that we will be, an opinion is forthcoming? Has there been any dialogue with this individual?
Yes. We have let him know that we always respond and let them know that the opinion will be considered at the next commission meeting. I let him know that we'd received an extension, and he is expecting, I'll give him an update either right after the meeting or tomorrow regarding whatever the decision is.
And so we need a majority of the commissioners to just approve this in order for us as a commission to, let's say, publish it?
Yes.
And this becomes it's not just a safe harbor for this individual.
You're right.
It's a guidance document for everyone.
It is a
Yeah.
guidance document, but it is only a safe harbor for the requesting individual.
Right.
But yes, you're exactly right.
So on the
Commissioner Berger?
yeah.
Commissioner Berger, are there any contours or just any areas in particular within the opinion that you would feel more comfortable if we were to make an adjustment in language, or are you opposed to the overall tenor of the opinion?
Well, I'm opposed to the findings of fact with regard to the one individual, just because I don't know.
To be clear, they're not findings. These are not findings of
We're precluding that,
fact. It's,
applying this particular exception.
well,
But couldn't they, say we send them this, couldn't they come back and say, but we have this other information we want to give you, do we fit now?
We have had it's rare, but we have had individuals come back and say, this is some additional information we want the commission to consider, and the commission has, on very rare occasions, issued a second opinion in that instance.
we have the authority to.
But we can't withdraw the opinion.
It's,
Or can we?
the commission has abrogated previous opinions before and replaced
I
it.
guess we have to rewrite it.
We could rewrite it, or if they want to submit different information that says, but this is the reasons why we do apply to this, then we could reconsider it.
Okay.
And because these Iris 990s, it's only like 1 or 2 lines, and it's probably, they spent $3 million. It's probably a lot more than, we don't know what it is that they're
But
getting.
in this particular case, I mean, just knowing what I know about the organization based on like Google searches, their goal is to be persuasive, which based on the statute, that can't be really the goal of an organization trying to fit under this exception.
So our holding then would be that anyone who has some history or intention of being persuasive on legislation.
They couldn't have been established to be persuasive. They have to, the goal is
So
to,
anyone
like they said,
established
yes.
to be persuasive or engage in a history of persuasiveness would be prohibited from this exception.
Yes.
Yeah, so I had a question about that. Caitlin, you have a block quote here in the draft, which is very helpful.
Absolutely.
Is there any way for us to see the rest of the statute?
Yeah.
Because I think you or the chairman said something about the executive director advocacy. So if it's an advocacy or persuasive organization, to use Tessa's comment, then it's prohibited. That to me would be a more clear-cut way.
That verbiage is not in the statute.
Okay, so if that were in the statute, I think that would be a very clear-cut way to say, sorry, I don't think you qualify.
Yeah, 237H, I mean, obviously, it's pretty deep in the statute. There's
Yeah.
a lot of other exceptions that exist in the statute as well.
Yeah.
This one is carved out for entities that are national, nonpartisan, nonprofit, and serve, strengthen, inform, and educate.
Right.
So that's, it's a pretty, at least our read of it, and the commission's historical read in 2012, is that it's a pretty narrow exception.
Yeah.
I doubt that I can't really imagine the organization would come back and claim that they serve and strengthen. I don't see that as a realistic.
That's where I'm struggling though, is being on record in an opinion, to use Mr. Berger's term, I guess, sort of fact finding that this organization doesn't strengthen. And this is pretty clear that they inform and they educate.
It's finding they don't do all four.
Right, but basically we're saying they don't strengthen and serve, right? I think we would agree they inform and educate.
Sure. Okay, I see what you're saying.
So we're sort of making a determination here that based on what we know of this group, they don't strengthen.
They weren't established for the purpose of serving, informing, educating, and strengthening. It doesn't mean they might do those things on occasion, in addition to doing advocacy, but if they weren't established for those purposes, they don't fall under this exception based on the statutory text.
But don't these other 2 organizations that exist that strengthen legislatures, don't they take policy positions?
I think
But they were, sorry, go ahead.
So, but if they take policy positions, why would that be any different?
the purpose, the reason why I'm using them as the example is because it's my understanding, without digging into these groups, that they were established for the purposes of serving and strengthening legislature.
But I think there's policy positions all over the place with those 2 groups. So
Yeah.
why would we
I
let
don't know
that?
about ESG, but I think that's true. I think
One of them, I don't
think.
think. So why would we let those 2 groups do it and not this group? That's what I
Because
don't
the
understand.
statute says they must be established for those
And
purposes.
just which part of the statute is that?
But it's in true, it's in the page 4.
It's in the block quote and
He's got the actual book.
it's got the real deal.
Yeah, it's 46-237 sub H.
Director Skoglund, what were the names of the organizations that you say exist and lobby in the state of Kansas for the purpose of serving, informing, educating, and strengthening state legislatures? You gave a couple examples.
They don't lobby, but they, as far as I'm aware, they don't engage in lobbying, but they are, the CSG, which I think is the Council on State Governments, and then the, NCSG, which, or NCSL, which is the National something on State Legislatures. A long time ago, when I was at the Nonpartisan Legislative Research Department, I attended an NCSL conference, and I don't recall discussion about policy positions when I was there, but that was quite a long time ago, and I don't trust my own memories.
I don't either.
He is counsel, by the way.
Council on State Government, okay, great.
But I guess I still have a problem with that group is allowed to do anything with policy.
And I don't know.
Then why would these other groups be precluded because they only do policy?
It's just this, I don't know the reasoning the legislature chose in drafting it. We're just operating based on the text of the statute, just the language that they have to be established for these 4 reasons. We didn't, yeah.
And to be clear, we're not saying in this opinion that NCSL and CSG do meet those.
When I haven't studied
they
them,
don't.
yeah.
I mean, but Caitlin and I are both the types of people who we lean very, very heavily on what the text says and allows. Very, very textualist interpreters. And so that is where I think Caitlin drafted the opinion.
Yeah.
With that in mind, that the statute will require this situation.
And I'm a textualist too, so I appreciate that. But we do seem to be concluding in this draft, sorry, Ed Choice or whoever you are, you don't appear to have been established to strengthen state legislatures. Therefore, the answer is no under H.
Based on the information.
Based on where we have. And so I guess my question is, do we have to go that far right now? Can we instead informally tell them like, hey, we don't really think you were established to strengthen state legislatures, but if you want to give us more information, we'd be happy to consider it.
The entity or the entity's request was, would Ed Choice as a nonprofit form to educate legislators and citizens in all states on the policy of school choice be permitted to provide reimbursement to legislators under this exception? So they are directly asking, does Ed Choice as an entity fit under 237H?
Yeah.
That is the direct question that has been posed.
I just wonder if there's a middle ground just before issuing a formal opinion, which we're kind of bound by down the road.
Right.
Could we say informally,
Where,
we don't think.
Within
we're
their
leaning towards
request.
No, but if you want to tell us why you think you meet the strengthen requirement, we're happy to hear it.
So
Yeah.
let me just add a line after that paragraph and say, should you provide other evidence, otherwise we would be happy to reassess.
we can do that.
I could vote for that.
Cool.
Can you repeat what your language test, please?
Hold on.
Can I
Yes, absolutely.
I think something to the effect of, should you believe that your organization does serve and strengthen state legislatures, you can provide that information and the commission could reassess.
I'd probably be okay with that, but I'd still probably prefer doing that informally as opposed to in an opinion.
So essentially,
Do it before we vote on the opinion.
so essentially not your position. I just want to try to parse things out so we don't have chaos in a vote. That you would vote to reject it, to not adopt today, but not reject it, hold it, and essentially have us contact them and say, we don't think you serve and strengthen. Tell us why you think you serve and strengthen. If you do.
I like that.
That's what I
And your
think.
answer is basically, well, we lobby. That's not going to be very much. So
Yeah,
Okay,
So we
I
better
just,
request more
But the
information.
educate legislators would say that.
I don't think there's a lot of dispute that they.
yeah, I think it's
inform
clear
and
they
educate.
inform and educate.
I think any lobbyist, frankly, informs and educates in one way or another.
Well,
so
does
then,
that resolve staff's concern though? Because it seems focused more on established.
I don't,
I think that would resolve the question, because if we were to ask, can you explain, how were you established to do these things? They'd have to show us and we can bring it to the commission.
Correct me if I'm wrong, but wouldn't that be a part of their charter, their foundational charter as a nonprofit organization? Would that indicate their purpose, their express purpose for existing?
Those are.
To be fair, they explicitly tell us what their purpose was in their request. He says in the request, would Ed Choice as a nonprofit formed to educate legislators and citizens in all states on the policy of school choice? be permitted to provide reimbursement under this exception. So that's kind of where, I mean, I'm leaning on what they provided as well. I am
Yeah.
happy, of course, to continue this to the next meeting, get a little bit more information so everybody feels more comfortable.
Yeah, I mean, if
But
there's enough.
the factual statement that you have here doesn't actually follow what they present to us. So that, I mean, that's where I got stuck initially. We're just saying, what do we have to believe and what do we get to investigate? And on the factual side, I think I'll always feel myself hung up on making a determination of someone's rights and administrative action. We're going to be specific about it, that deprives an individual of certain things that then forces them into a position of having to litigate it. Because that would be the only choice within 30 days. Or we can provide just the opinion on how we interpret these provisions, which there seems to be some pregnancies in here. I mean, number one, we are saying that what they're doing is lobbying. That's the first presumption that's in here for answering question number one. Number two is the nonprofit thing, which that seems very straightforward. I would just kind of be wary of giving them any advice on how to be a proper nonprofit. That's not our business. And then number three, we're saying that we are narrowly interpreting this, which I didn't read that prior opinion to say that. Because that was a Florida case. That seemed like a very cut and dried situation.
Is that the 2012-09?
Yeah, it's a short one too. That it is not necessary, maybe we want to be narrow, but I'm not agreeing that we had been or that it necessarily should be. And now, I mean, we're getting some pretty thick issues about how we interpret everything so that it doesn't apply just to these folks, but it applies neutrally to everyone down the road. And I pity all the poor judges in the world. That's all I can say.
Chris, what was the 30 days you referenced?
So anytime that a state agency takes an action or an inaction that affects somebody's rights effectively, they have 30 days to file a petition for judicial review under the KJRA, where it's called nowadays.
I'm not entirely, I may be wrong about this, but I'm not entirely sure that the formal opinions can be appealed under the KJRA.
But
Because
I'm
it's-
saying it's an action that would be a
Oh, I see.
declaration that they do not have the power to do this particular activity. They probably wouldn't appreciate that. So interwebs, they probably wouldn't appreciate that, but I will assure you that the state's attorneys would. Having been one who's pulled that old chestnut out of his pocket decades ago. But anyway.
If you're correct about that 30-day thing, to me, that would be all the more reason to slow down and do the informal approach rather than issue an opinion saying no and starting that 30-day clock.
I would be fair.
Even if we end up saying no a month from now or whatever.
I think
Just
that's where
this-
we're all, I think that's where we're all at, it sounds like. We want more time to gather more information.
Yeah, because the opinion that just says, sorry, we don't think you strengthen state legislatures, which we're kind of saying here, maybe that's the right answer. But I think we want to be certain. Yeah, that's the right answer.
Because it applies to other groups.
Because any AO is going to set a precedent for other groups down the road.
Yeah.
Sorry, I'm repeating myself, but that's my.
And how does it fit in with lobbying? And I'm really opening that up, and I know, and I don't want to have that conversation because we have a day. 225, seems to be promoting or opposing specific legislation.
It is presumed in the question that they are engaging in lobbying.
That's why.
I didn't read it that way, though.
He asked if they exceed the $1,000 registration threshold for law, like that's a lobbying threshold.
And I get, but the question is, if there is a seminar, which is a general, kind of like, educational, I approve of this message, sort of general educational message. Education's wrong because they are in the world of education. Then all those things count as lobbying. When there's a seminar that everyone attends where there's a general discussion about process or policy or procedure, that constitutes lobbying.
That is not the question. And the reason we're being cautious there is that what is or is not lobbying is more nuanced and complex.
Yeah.
And they are presenting the question in a way that there is a presumption that they are engaging in lobbying.
We don't want to answer questions that they're not asking.
Well, we are specifically saying that they would be expended for lobbying.
That's
They are
what they're
saying
asking.
that.
That is their question. Even if Ed Choice exceeds the $1,000 registration threshold, which is a threshold for $1,000 expended for lobbying.
Gotcha. So the question as posed, so that,
Yes.
so the answer there would be, we are working under the assumption that you are engaged in lobbying.
Yes,
I believe, I thought I had that in there, actually.
As posed.
as posed, yeah.
But again, I would look at the question, I would interpret that as being a finding that this constitutes lobbying.
Right, we were trying to avoid
If that was
answering
changed,
the question they were asking.
we're just assuming that you are engaged in the statutory definition of lobbying. Then, yeah, of course, $1,000 wouldn't seem to be.
Right.
So I think they were asking if it is lobbying. Anyway, so that's a giant thing in and of itself.
Okay, so more time?
Yeah, well, I think this is helpful feedback, and I think this is just part of the process that we go through. I mean, for something like an advisory or a guiding opinion, advisory opinion, it's just inherently nuanced. And I think giving the commissioners the opportunity to tinker with it, I think is productive and helpful. I will say that I do give a lot of deference to the issuance of guidance. It is kind of the goal that we are able to provide information that people would find helpful. It sounds like in this situation, some of the focus centers on that last paragraph on page 3 and the top paragraph on page 4. I guess from my standpoint, I see that we could perhaps resolve this by just speaking more hypothetically, or perhaps language to the effect, you know, in the absence of more information, or in the event that we were to take in more information, that that could obviously have influence. So, Caitlin, is it fair to say that we'll just expect to see this opinion at the next meeting?
With more information, absolutely.
And if I
Okay.
could make a quick comment, Mr. Chairman, I do think that this discussion is really good. I, in general, think it's a good idea for the commission, especially on advisory opinions, that I think that it's possible that there are people who want to just adopt the opinion today. In general, I think it's probably a good idea to, instead of just getting 5 votes to pass an opinion, I think it would be better to have better discussion and get 7 or 8 votes, sometimes even 9 for an opinion. So I think that this is good, and I appreciate the commentary and sending it back, even if there are votes today to adopt it. I think that there are some good questions being asked, and
Absolutely.
I think that I'm looking forward to the discussion next month.
Thank you all.
Maybe a little and late, but on this expansion, we're now going to ask this agency to tell us more about what they are and what we are before we try to express an opinion. Does anyone else know that we're comparably engaged in this type of behavior, what we're doing here? So when we issue the opinion that, well, if we had a chance to chime in on this, we might have wanted a different outcome. So we have a very narrow question. We have a number of agencies that might very well be intricately interested in this question. They don't know about it.
And looking at the opinion statute, I'm just reading it here again, but it's not just this person who gets the safe harbor. It's any person who acts in accordance with the provisions of such an opinion.
Yes.
So
Any person.
So once we open the door to ask this agency, tell us more about why we're going down this path on this particular question, we could have ancillary people in the same position or relatively the same position who don't get to provide that information. So opinion is still going to be limited to one very specific factual setting.
No. Like, you're saying you can limit it into uselessness, or that we should?
So. And how does that differ from anything we get from the AG's office or from the Office of Disciplinary Administrator or any other agencies that do this type of thing? Well, you ask for an opinion about, for instance, when I took the bench, I asked because I owned a building that was occupied by the state parole office. What impact does that have to me as the owner of this building taking the road? That's very particular to me, but it may apply to a number of other attorneys. Again, I don't want to create more problems here, but I'm just saying, while we're being expansive to get more information back from this group, we've got a lot of other people out here in the same pond.
Well, thank you, Caitlin, for for writing the opinion and for your thorough explanation. I also think that this conversation was helpful, and we'll just look forward to seeing it at the next meeting. Going back to the agenda, we also have a general counsel's update. That's the next item. Caitlin, do you want to give us that update?
Absolutely. So some of this will be review, but we have a lot of new commissioners, and so I felt it appropriate. And a couple of commissioners last time raised questions regarding relevant proof thresholds for different stages at the investigatory and or in the complaint process. So I'm not going to verbatim read through my opinion. I have this as a resource for you all to look back again. I did also want to note that the recess session materials in front of the commissioners will always have the relevant proof thresholds at the very front of the materials. So those are always there for you to refer back to. Jesse, that's there for you too for convenience. But walking briefly through the different proof thresholds, the first is reasonable suspicion, which typically that's only really coming up in the investigatory stage rather than the complaint process. And the reasonable suspicion that applies to the commission is not defined any differently than reasonable suspicion in the criminal context. So it is a very low burden. It is a particularized and objective basis for suspecting a person is involved in criminal activity. And I say a person because our statute, in particular 254158 sub D, which is where reasonable suspicion is used. And that comes about when the commission is issuing subpoenas ducis tecum and other subpoenas. The commission must have a reasonable suspicion that a person has violated the Campaign Finance Act, not necessarily that a specific individual has or that we have all the specifics of what occurred, but just that there is a reasonable suspicion of a violation.
Two questions on that.
Sure.
I was looking at the statute. Our reasonable suspicion, we're supposed to make written findings of fact and conclusions of law for each one.
Yes.
I don't remember doing that.
That's in every subpoena issued by the commission includes findings of fact, conclusions.
That's concluded in the act.
That's in the subpoena itself, but when we make our finding of reasonable suspicion, it's supposed to be based off of our written findings of fact and conclusions of law.
And they're submitted as part of the written application for subpoena. It includes findings and conclusions. And because there's no other party, they're just submitted by the executive director for adoption by the commission. And the commission has, in fact, without going into, we can't talk about the confidential sessions, of course, but the commission has, in my tenure here, even amended some of the language presented in the findings and conclusions and adopted with the amendments.
Okay. And is it the commission's belief that the perceived belief of a violation without a violator is sufficient to do this?
It's not that there's no violator, but sometimes at that point in an investigation, we don't know who made what decisions. We just know that there may be evidence of, again, I'm trying to be really careful here. Great.
Yeah, so
Thank you.
for example, if a text message is sent, that blast text message that clearly was a paid for matter, had express advocacy in it, did not include a paid for. Doesn't say who it was by. We have no idea who distributed that message, but they needed a paid for attribution on it. We can issue a subpoena to text messaging providers, to vendors who provide that kind of material. Even though we have no idea who violated it, we do have reasonable suspicion that a violation occurred. In fact, we've got quite a bit more than reasonable suspicion there. You have the evidence that it happened. But in that type of case, that's a great example of, we don't know who did it, but we have to investigate to find that out. So, and that's why the statute is actually explicitly written to say that that we can make a violation, correct? Yeah.
Mm-hmm. And so that's reasonable suspicion, which again hasn't come up yet a ton. The next is sufficiency. This is the sufficiency, probable cause, and clear and convincing are all the different proof thresholds for the administrative complaint process. So sufficiency is a fairly simple evaluation by the commission. It is just once a complaint is filed, the commission first considers it for sufficiency. And essentially the question at issue is just whether the complaint is properly drafted to assert a violation over which the commission would have jurisdiction. I kind of compared it to a Chapter 60 motion to dismiss, but it's even a lower burden than that, because it is just a question of, do they use the proper form that's required by statute? Do they provide the complainant's name, address, the respondent's name, address? Do they allege facts? And do they actually present a statute that they believe was violated that is within the commission's jurisdiction? So sufficiency is a very, very low burden on part of the complainant. The next is probable cause, which I have spent a lot of time adding bulk to this discussion compared to my very first general counsel's update. The commission must find probable cause before a complaint becomes public or a matter is set for hearing. So after the commission determines a complaint is sufficient, the statute is written so that investigation may occur. There may be additional investigation before probable cause is addressed. But once a complaint is up for probable cause, the question again is the same as probable cause in the criminal context, which is that it is the reasonable belief that a specific violation has been or is being committed, and that in this instance, there's a named party, that the respondent themselves committed that violation. When determining probable cause, the Kansas Supreme Court considers the totality of the circumstances, as the commission does as well. And notably, probable cause does not require convincing evidence, but only so much reasonably trustworthy information as to warrant a prudent person to believe that the respondent has committed or is committing a violation of either Chapter 25 or Chapter 46. And I found a very helpful quote in an appellate court opinion, State versus Kramer, that determinations of probable cause, and I'm paraphrasing a bit because it was about criminal liability, but determinations of probable cause are concerned with the probability that something happened and that someone did that thing, not the exact liability of that person who committed the event. So things such as affirmative defenses aren't necessarily considered for probable cause, because an affirmative defense is, I did that thing, but that thing was justified for XYZ reason. There are some illustrations that I've included here for what criminal courts or district courts have considered for probable cause. For instance, typically probable cause requires more than an unverified tip, but it could be established with an unverified tip if it's corroborated with other evidence. Kansas courts have also held that which rarely will the commission see matters with an unidentified informant. That really just doesn't happen much, particularly without any type of corroboration, considering a lot of the world that we're dealing with is public documents, receipts and expenditures reports, things like that. Kansas courts find that, the most favored are from identified informants. Again, that's typically what we would see in front of the commission. And if the commission essentially believes the totality of the circumstances will warrant a prudent person to believe that a respondent committed a violation of the Campaign Finance Act or the ethics laws, the commission would find probable cause in that matter. The commission's task is just, again, a very helpful quote I found from a court describing a magistrate's role with probable cause, is that the task is simple to make a practical common sense decision, whether given all the evidence provided for probable cause, including the veracity and the basis of knowledge of any informants, if there's a fair probability that evidence that that particular individual committed a violation would be found. So again, the probable cause stage is the final aspect of the very confidential aspect of the complaint process, where the commission makes its decision behind closed doors. Once probable cause is found, the matter is then set for hearing and the complaint becomes public. The final aspect, the final standard that applies is clear and convincing. This is at our civil fine hearing level, which is where we'll be going later today. The commission is required to comply with a heightened clear and convincing standard, but that is not as high as beyond a reasonable doubt. Kansas courts have indicated that it is not a level of proof higher than preponderance, but is about the quality of the evidence that is provided. That it is a better quality of evidence than would be required for preponderance. And if anybody, that's all I had with the proof thresholds. If anyone has questions there, I'll move on to the two other matters I wanted to address.
That's all really helpful. I have one basic logistical question.
Absolutely.
The statute uses the word filed a lot. And that really just means sent to the proposed respondent and circulated to the commission.
Yes,
Right?
yes. We don't have like a filing system.
There's
or
no electronic,
If only we had.
Sure of
that.
that.
Yes, that'd be lovely.
which is why when we're reviewing things in terms of the probable cause determination, at that point, it does become public, which we discussed at the last meeting. Whereas when it's just at the sufficiency stage, the only people who know about it are the proposed respondent and the commission.
And when addressing probable cause, the only ones that actually know the identified parties are the commission. It's after that
Yeah.
probable cause finding that it becomes public. Yeah,
The word filing or the filed is throwing me off.
I understand. And the filed is why we always email you all, sometimes quite a lot, because we want the commission to be alerted the moment something is filed with the office.
Yeah.
And there's not a filing system that we have.
And a member of the public can file a complaint,
Absolutely.
which basically could be filling out a form or sending it to you, and then you upload it for us to review.
Yes.
That is a filing.
Yes. Yes.
Yes.
So the other thing that we addressed is the next matter is how the commission procedures will operate if there were a concurrent criminal prosecution. And this comes up because Chapter 46 and Chapter 25, most of those civil violations are also misdemeanors. And as we're getting ready for another election cycle, I found it prudent to, Mark and I consulted with the Shawnee County District Attorney and his chief deputy and had a conversation about how the commission should best proceed to not step on the toes of the prosecution. The Campaign Finance Act typically presumes that the commission acts first. The way that it is drafted indicates that, for example, after the commission makes its finding, it then sends its report in order to the district attorney or the county attorney that would be appropriate. There are times, though, where the commission is either engaged in multi-agency investigations or we act after the prosecution has already commenced. So after a conversation with the prosecutors, it was incredibly helpful, and we really appreciated them taking their time because they are very busy. They were generally unconcerned with interactions other than two areas of concern that they asked be kept in mind. The first was the timing of commission hearings, because as Commissioner Jackson pointed out, that is when things become public. The second aspect they were concerned about would be the commission compelling a respondent to testify or produce information. The latter issue is less likely to come up, so I will address that later. The concern about the public matter of the hearing are that prosecutors have an obligation to ensure investigatory facts are not released to the public in a way that could interfere with jury selection. Importantly, as we've mentioned, the only part that becomes public pursuant to our statutes after probable cause is found is the complaint itself. Complaints filed with the commission do not allege facts beyond those that would be found in a charging affidavit in a criminal case. As I mentioned, the sufficiency test is very low. It's just, are some facts alleged that, and is a portion of the statute highlighted that would have been violated if those facts were true.
Is the public nature of it, is that by statute that
Yeah.
only the complaint becomes public?
Yes. Yes, it's KSA 254161 sub E and KSA 46256 sub E. Once the commission finds probable cause, then it may inform a prosecutor that there has been a complaint filed under Chapter 25 or 46. If the commission has not found probable cause, then neither the commission nor its staff can confirm or deny the existence of a complaint at all, which means until the commission finds probable cause, there could be no discussion with prosecutors. This would then, if after the commission finds probable cause, it would allow for a dialogue since no one would be dealing in hypothetical scenarios. Again, the issue is with the public hearing itself, not the finding of probable cause. It's about the timing of the public hearing. Yes.
And if I might add to that as well, we, on this call, which again was very helpful, after they talked for quite a while, we asked them very specifically about to drill down on what specifically would cause a concern about the jury pool. And they said it was the evidence that would come out at a hearing. And they said specifically they have no concern with probable cause. Their concern is when the hearing takes place. So we did ask them to be pretty
Meaning our
specific.
hearing.
Yes,
Yeah.
our hearing.
Our hearing. Yeah, they asked that I'm not gonna step on your toes.
They asked that we stay the public hearing until the prosecution gives us the go-ahead. So once the commission finds probable cause on something, if we are aware that there is also a concurrent criminal matter, we will let the prosecution know that a complaint has been, their probable cause has been found, there's a complaint, and to let us know when we may proceed with the public hearing. We would just stay the public hearing until we get their authority to proceed. Does anyone have any questions about that?
What
before I-
did they say that their use of that finding would be a trial?
What? I'm sorry.
Did they make any reference to a commission making a finding of probable cause for a violation, and whether they would use that as evidence at trial?
No, that would be wholly separate because that probable cause determination is an administrative civil matter. It's different from what
Did they say they make it inadmissible?
they, no, they had no concerns about admissibility
They
with,
made no comments about that at all.
no, that was not their concern.
But it's not their concern, because that would be to their advantage. And when did you have a discussion about whether or not they would use a finding from this commission in their prosecution of a criminal case?
I'm not sure how they could. We don't distribute a document or anything that says we found probable cause, except to the,
But we make it public.
We,
it is public, but I
We're a
can't really
civil-
imagine.
We're a civil agency.
Right.
Right.
You're not gonna be, I don't think,
Well, lesser
as a
standard.
trial judge, I'm not gonna allow that in as a foundational issue.
Right. Just because a different
It's not
entity,
relevant, right? It's a different standard.
Mhm.
Not to say that some trial judge might. I can see that, but.
Trial judges are allowed to be wrong.
And we can be right again, and we can be right again. It just depends on how many times they go to schedule. Another question on that,
sure.
if we schedule a hearing, what if an attorney is involved and they want to use that perhaps as an opportunity for a pseudo preliminary hearing? They use it as a discovery tool in the hopes that they can gather something, because they know some things that they think they can orchestrate within this hearing that would be beneficial to them later for a witness testifying at the criminal side, and use it somewhat as a deposition.
yeah, so we asked them a little bit about when we would be obligated to provide certain information to them. For example, do you remember the details of the Brady discussion we had?
Or wouldn't they give a transcript? Wouldn't they be entitled to?
If we had the hearing, but I think
I think
we would
Commissioner
hold-
Helmer's question is about the defendant. Is that right?
I think we would hold the hearing until such time that the prosecution either concluded either
But
with,
what if the complaint demands that you proceed with the hearing?
commission doesn't have to agree to that.
Okay, but they can demand that, right?
I think they can demand anything they'd like.
Okay.
Just like we could say, we want to move ahead with it. I
Just play the devil's.
no, absolutely. And I'm agreeing. I think that is, any party could move the commission to make certain, to move the hearing forward, to advance it. The commission could,
I just see opportunities for appeal and constitutional review, denial of process, et cetera, you know.
I mean,
That's okay.
they, yeah, and anytime, since many of the issues, this kind of goes to the second issue that I'm not gonna step on Caitlin's toes here on what that is really, but the, realistically, when we engage in discovery, which post-complaint discovery only happens after a finding of probable cause, again, that only occurs with the authorization of the hearing officer, who again, presumably there would be discussion with the prosecutor on the case in whatever district attorney or prosecutor's office is handling the matter about when and what we can do without stepping on their toes.
So you're suggesting the hearing officer would coordinate with the prosecutor?
No, I'm saying that anytime that we are discussing about the timing of everything after probable cause, about, I think the judge's concern was about when basically having certain discovery matters occur and use them in a prosecution, either favorable to one side or the other. And there's no reason the commission ever has to agree to those at all. The hearing officer does not have to accede to any discovery requests.
Well, she can.
Right.
Yes.
Putting on the hook.
Okay.
Yes, and that's the other thing for our post-complaint discovery is still has to be approved by the hearing officer. It's 254163 that explicitly addresses that. It says if a hearing is to be held pursuant to the act, before the hearing has commenced, the commission shall issue subpoenas and subpoenas juris tecum at the request. But again, the hearing officer has the choice to do that. Shall do so doesn't mean that it has to happen immediately, because the statute doesn't have any language regarding timing. And I confidently feel that the commission trying not to interfere with the prosecution of a matter is a legitimate justification for staying discovery and the civil hearing.
So much for constructionalist. Shall issue.
I love
Shall, it says shall, it does not identify a time period in which it shall be done. Which means the commission shall do it, but again, doesn't have to be done immediately.
We need an AI application to get all of these things.
No, indeed. Yes, you're-
I do find it super confusing why we have the 46 and the 25.
Me too.
Uh,
It's going back and forth for the books over here.
And two complete different codes.
Yeah,
And what's interesting is there's even provisions that specifically carve things out so they don't cross the streams. There's a specific part of the gift laws that say that any contribution given under the Campaign Finance Act is not considered a gift unless it was done in exchange for official action. And so they keep their separate as much as possible.
wow.
Which is, as much as it means that there's a larger body of law for us to deal with on the procedural side.
Yeah,
It is very nice in the substantive side
yeah.
because it means that we don't have awkward crossover between those two universes, which would be very difficult, I think.
Yeah.
Okay, does anyone have any other questions on that? Okay, my last thing, and then I will be quiet for a while. So the last matter is that we've had several default proceedings. So Mark and I met with the Office of Administrative Hearings and, discussed, we want to be, because if, for those of you that are new, as of last April, after the commission finds probable cause, a respondent may elect, we haven't seen this happen yet, but may elect to remove the action and have it heard, rather than in front of the commission, heard in front of the Office of Administrative Hearings. The commission has the final say, but they can elect to have it heard by OAH. And so we want to try, and also the Kansas Administrative Procedures Act did not apply to the commission until last April. So we want to try and interpret it as consistently with the Office of Administrative Hearings as we can. So we discussed default matters, and we're kind of curious of how they dealt with them. So the way that they deal with default matters, particularly if there is a pre-hearing conference, which has been the practice as of late. 77-520 of the Kansas Administrative Procedures Act, just another part of the code to go look at. It states that if a party fails to attend any stage of the adjudicated proceeding, they may be found in default. There is, again, a distinction between finding a party in default and granting default judgment. That default judgment can only be granted by the commission via a majority vote or through the Office of Administrative Hearings, and then the commission has the final say through majority vote again. So the way that they handle default matters is that there's a choice. Either the adjudicated body can choose to hear testimony from the party who appears, or they can choose to just adopt the materials that the appearing party has asserted as facts and render conclusions of law based on the information available. The latter option for the default hearings somewhat functions more like a docket call, where each matter is just quickly listed and disposed of because of the non-appearance. So for the purposes of the commission, that means if a party fails to attend a pre-hearing conference, then they may be found in default by the presiding officer, presiding member on the day of the actual hearing. The commission can choose to have us fully walk through the facts, or to just hear testimony from the appearing parties, or to adopt any proposed findings and conclusions based on the information that has been presented. So that's kind of just so we're all aware of the parameters that OAH follows and the choices that the commission has that would still be consistent with their practice. Does anyone have questions about that? Otherwise, I am.
Could you educate us, please, on, assume that there will be a request to go to OAH and they hear the matter and they make a decision. What can we do about that when it comes back to us? What authority do we really have?
So the commission cannot rehear the matter after it goes to OIH, but just makes a final determination based on the record of the hearing that is presented in front of the commission. So there's no new fact finding, but essentially, if the commission were to disagree with a question of law, it would allow the commission to make a decision there. But frankly, the commission does not have a ton of discretion.
Realistically, I think the most common scenario is that a hearing by OAH is rather likely to not be as generous as the commission typically is. They will say there's a violation. You're not here. We're going to assess the maximum. We're done here.
Mhm.
And when it comes back to the commission could amend that. I think they have to provide a rationale for it. When they alter the initial determination by OAH. It's been in the essence of looking at the statute, but I believe they need to articulate a rationale for it.
Mhm.
But the commission could be more generous than OAH was in that moment. Or they could say, well, you went to OAH and that was their decision. We will just adopt their findings. So I think that there are ways that the final determination by the commission could occur. I think in practice, it's likely that the commission is likely to be more generous than OAH rather than alter a major finding of any kind.
But then also then allow the respondent to ask us to, let's assume we in some way modify the determination of the OAH, and they're still believing it's too burdensome, too punitive. Do they still have the right to ask us to review that as they do now?
I think that when it comes back to the commission for final decision, I don't know why the respondent would not have the opportunity to say anything, but I'm not familiar with the final determination process yet, since we've never dealt with it.
Well, this hasn't been
I guess.
fully tested. It appears they should still be able to file a motion for reconsideration, but
Right.
that they can't. We couldn't do a new hearing.
And so I think,
agrees it's not a de novo issue.
yeah, I think the motion to reconsideration would also go to OAH rather than us. Because they went to OAH, we don't have the authority to hear evidence. So even if we
So
granted
they
it,
reverse it to OAH, say, here, see what you can do about our decision.
right?
This is a very helpful document. Caitlin, thank you for putting this together on all three counts at the last meeting. This was information that we sought more guidance on, and you certainly delivered. So thank you for all your work here. And
Yeah, thank you for
Mark.
your patience.
Yeah. Turning back to the agenda, our next item is a couple of policies. Did you want to discuss this, Director Scoglin?
Sure, I'll take it, if for no other reason than to give Caitlin a break. You might recall at the COMA training that we had, thanks again to the Attorney General's office for providing that. It was extremely helpful. They recommended having a written COMA and CORA policy articulating what restrictions, if any, would apply to open meetings. So the commission has to, by the Open Meetings Act, we obviously have to allow certain recording, audio, things like that. However, there are certain things that can be restricted. Like, for example, we do have to allow the use of cameras and photographic lights and recording devices, but the use of them have to be subject to reasonable rules. So by their recommendation, this document sets those rules. The only restrictions that we have wrote into the policy so far, and I think this could be a document that we end up revisiting in future, but I think this is good as is today. There are two restrictions for COMA. The first one is that audio and video recordings is permitted, but if they leave a recording device in the meeting room during a confidential recess or a confidential executive session while recording, then they have to delete the entirety of the recording, which is not necessarily atypical for when we have a recording that includes impermissible material. The second item is photography is permitted, but to not use flash photography or other lighting equipment. I don't know who's going to give in here with a large 8-foot backlight of any kind, but I don't want that to happen and have us not have a policy today. Please don't do that. So that's the first policy. I'm just going to move on to the second one real quick because there's not a lot to discuss, but then I'll see if there's any questions. The second one is the Open Records Act policy. A couple little issues here. The first is that they must submit the CORA request in writing, which was the request that essentially the strong recommendation of the Attorney General's office to avoid issues and miscommunications, which we definitely appreciate. Otherwise, we really are asserting all of the normal items that we could charge fees. We typically do not, but we could charge and require advance payment of fees as needed. For example, if someone requested a lot of documents that required a ton of staff time to produce, then we would provide them, but there may be a fee associated with it. Again, we typically, in my tenure, we have not ever charged a fee for Cora documents. And I don't intend to unless there's a universe where we have to because of the quantity. But again, the statute allows us to do that if needed, and this is included in the policy. Also, obviously, we still have all our rights to not disclose something if the Cora policy includes an exception that allows us to not produce it. For example, we have confidential information that's part of investigations or complaints that we can't produce in many circumstances, and we would not produce them subject to both Cora exceptions and commission statutes. Any questions about the Cora or COMA policies? And thanks to Caitlin for all the work on it as
So
well.
these would go online then somewhere.
Yeah, these would be policies that we would put online, probably in the same place we put our guidance documents.
Create a policies tab or something.
Yeah.
It makes sense to me. I just had a question or a comment about the first bullet in 2024-01.
Mhm.
Maybe it's just the wording, then such device must delete the entirety of the recording in the presence of the ED or
Oh.
GC.
Such person must delete.
Yeah, I was gonna say such person
Oh, that's good.
must
you.
delete the entirety, and then I would maybe clarify the entirety of said recording or the recording of said confidential portion of the commission's meeting. You know what I mean?
Absolutely. Yeah, yeah.
Because what if the device has other totally unrelated recordings?
Right.
Yes. Oh, yeah,
I
yeah.
think we just want to make it clear that the person who had that device that was recording improperly, the confidential portion,
So what about
he or she shall delete
such
that.
person must delete the entirety of the recording of such confidential recess or executive session in the presence
Of the commission, yeah.
Yeah.
Okay.
That can be hard to control too.
It's a redaction, in other words. How do we verify that?
Oh,
Where's the record that being done?
Yeah,
How's it verified?
if something ends up being uploaded to the cloud at the same time.
Right.
That's a good point.
Oh, we just can do the best we can. I mean, realistically, the policy
Well,
just states,
The worst
this is what you have to
thing that we
do.
can rely upon is a written document or something that says, okay, this event happened. We corrected in this manner. You sign off on it, they sign off on it. This is what's done. Where do we have that?
Oh, when this happens, you're saying.
do we want to, okay, add like
I would feel.
an attestation?
I feel more comfortable we have some verification document that's signed by all parties indicating this event A happened and B that it was corrected.
Yeah, and we can include that in the end of that as well, that the impermissible recorder shall sign a document attesting that they will delete any later found recordings of the same and do not use or distribute in any manner.
I want to tweak it a little bit.
Yeah, but we get the idea.
Yeah,
Just
absolutely.
something to.
If the commission is comfortable,
That's a really good.
We know what
That's a good idea.
if the commission is comfortable adopting that conceptually, I think that we understand what the,
And the idea behind that, Commissioner, is to make certain that everything is deleted.
Well, not only make certain of it, but no one else knows about it. So if we look back, we have all new commissioners here. They don't know about it, what we've done in the past. And I don't
Documentation.
been part of that. And someone comes in and says, well, wait a minute, we heard this, or we saw this, or it was published, or it was somehow there. We have no record of whether this was actually done or not. It's protection of them as well as us.
Yeah,
yeah,
Look,
that's a good point.
attempted our best to comply with the rules and regulations, and we did this. Well, you say you did it. Mark doesn't have anything written down in the file that says it was done. We have documents. Protects everyone.
Yeah, and you typically, when this happens, it's only happened, I think, a couple times in, as far as I'm aware, commission history, or at least the last 15 years or so.
almost always an accident.
And it's an accident typically by a member of the media who forgot their recorder. And they're pretty quick too, and they can't use it. So they know there's issues with that. So
Well, I think
it's that
typically we're
adaptation
gonna
will help
find
them
it's
as
just
well.
an inadvertent event. that's
Yeah,
happened.
Absolutely.
Mhm.
So let's keep it in that format.
Yeah.
Let's just have a record set.
Yeah, that was a really good addition.
So we want an action of the commission to approve both policies. Is that the idea?
That'd be the request, yes.
Yeah.
As
Just-
amended as amended from this discussion.
Yeah, fair. Just on that point, there's one other item that I noticed in policy number 2, just in the second to last paragraph in the first sentence. We say pursuant to KSA 45221, the commission reserves the right to refuse to produce the requested public records requested. Just
Oh,
strikes me that
thank
we
you.
put the word in twice.
Yes.
We really want you to know that they were requested.
Anything else that we're spotting? Anything else? Any other feedback apart from what's already been discussed? If not, we'll take a motion to approve.
They look very standard for what I've seen, with district courts.
Yeah.
Yeah.
Good.
Any commissioners wish to make a motion to approve as amended in this discussion?
I would so move to adopt as amended in discussion, both policies.
Second.
Any additional discussion? Hearing none, all in favor of approving the motion to approve as amended signify by saying aye.
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 All opposed, say nay. The motion passes. Returning to the agenda, we have some civil penalty assessments to simply note for the record.
Yep, we just have to amended January 2024 receipts and expenditures reports. They both hit the maximum $300. This is the calm before the storm, this month and a little bit of next month. August, obviously there will be quite a few, and then September will be very busy on. It's going to be a long list of penalties. We're trying our best to get ahead of them, so
Okay.
just a fair warning.
If there are no questions, we'll move on. The next item on the agenda are civil fine hearings, and Director Skoglund, do you want to just help us understand how we should go about these today?
Caitlin?
Yes,
Excuse me.
Sorry. Order wise.
Either way, I don't think either of them are here.
Yeah, let me take a look outside real quick.
There were continuances requested, couple dismissals.
Yeah, we can handle the procedural ones first, just to knock those out.
Yes.
Because there are 7 that are scheduled, but obviously there are a couple matters for which we've requested dismissal. There's 3, I think, that we've requested continuances on. So whatever, I think that we should do the procedural items first, just to, I know it's our 232. It's unlikely that these 2 respondents are likely to appear, but that said, I think that it's a good idea for us to give the extra 3 minutes or so that we're going to take on the procedural matters.
Yes. So those 2 procedural,
We're just gonna ignore 769.
well, actually 772 is where we begin the housekeeping.
Do you want to lead?
Yeah, so complaint number 772 is Mark Skoglund, ex-rel, Mark Skoglund as the complainant versus Jose Cabrera, candidate for state representative. And complaint number 773 is Mark Skoglund versus William Barajas, treasurer for Jose Cabrera. We have filed motions to dismiss and have presented Commissioner Helmer as the presiding member, and you all have seen them as well. Proposed orders for dismissal. We have had all outstanding reports have been filed by the candidate. So there is typical commission practice, as was represented in the motion, is to dismiss once compliance has been achieved.
So they paid the penalties, they just don't have a fine.
They have not paid their penalties yet, but that is a well, we're asking to dismiss so that we don't find a fine. They do have penalties that are still outstanding, the late fees.
Okay,
But with,
they're still liable for those.
yes, they are still liable for those, to be clear, yes. So that is my request, is that the commission dismiss complaint number 772 and 773 and adopt the proposed order for dismissal.
Do
It
any
makes sense to
commissioners-
me. Well, I just had one quick question. Sorry, Mr. Chairman. Do we lose any leverage in terms of getting them to file those late fees after these are dismissed?
We have, I'm in a payment plan with both of them, and we have the Kansas debt recovery set-off system to use, which if they don't pay their penalties, and we've already sent them 3 notices, then we can essentially submit them to that system, and it will take money, any money owed by the state of Kansas to them will be diverted to us. So tax returns, things such as that.
Got it. Thank you.
Also the do not file list.
Oh, yes. Also, they are on the do not file list so long as they have not paid their civil penalties, which means they cannot file to run for office. So it is a strong incentive to get them
Is
paid.
that a public document?
The do not file list, yes. I don't know if it's on.
It's not a non-public document, I think is a better way of saying it. If we were requested, if someone asked for it, we would provide it, but we don't post it anywhere.
Mhm.
Or would it be in a public document, would that give them some incentive to pay their fines or penalties or anything?
I don't know.
Well, all of our commission meetings, if you were to search their names, the
They'd
civil
show up.
penalty assessments,
Okay.
they would show up.
All right,
Yes.
Same thing.
Mhm.
So we need a motion from a commissioner to approve the motions of dismissal in both matters and adopt the findings of fact and conclusions of law. Is that accurately stated, Caitlin?
There aren't findings and conclusions with the proposed order. It is just a proposed order,
Got it.
just to adopt the proposed order. Sorry.
Got it.
Thank you.
I'll make that motion.
I'll
Thank you,
second.
Commissioner Jackson. Thank you, Commissioner Glenn. Any additional discussion? Hearing none, all in favor of approving the motion to dismiss complaints 772 and 773 signify by saying aye.
Aye.
All opposed say nay. The motion passes.
The only other thing is, I believe that Commissioner Helmer needs to be given explicit authority to sign the proposed order as the hearing officer.
So moved.
Second.
Any additional discussion? Hearing none, all in favor of approving the motion to grant Commissioner Helmer authority signify by saying aye.
Aye.
All opposed say nay. The motion passes.
Okay. The next request are for complaints number 774, 775, and 777. That is Brad Boyd, Stephanie Yeager, and Paula Rogie. We have filed motions to continue due to service issues. And Commissioner Solbach is not present as the hearing officer today, so I guess this just goes to the commission as a whole. We just request these hearings and pre-hearing conference be continued, the hearing at least until the July meeting.
So moved. Second.
Motion has been made and seconded. Any additional discussion?
Mr. Chairman, I'd like to recuse myself from complaint number 774.
Noted. Thank you, Commissioner Harrison. We'll still take one. Well, what do you think, Caitlin? Should we take two motions? One with respect to 774, or should we, does it make sense to group all three?
I think all three can be clearly grouped.
Okay. Commissioners, Harrison's abstaining from complaint 774 is noted for the record. Do any commissioners wish to make a motion to approve the motion for continuance in these three matters?
So moved.
Any seconds?
Second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion for continuance in these three matters signify by saying aye.
Aye.
All opposed say nay. The motion passes. We'll now return to the top at complaint 769.
Okay. Yes.
Chair, with permission, I would like to proceed with a hearing on the matter of Mark Skoglin, Executive Director versus Joshua White, complaint number 769.
Yes, please proceed.
Thank you. For the record, it appears that we have no other parties appearing on behalf of either the respondent or someone on their behalf. Is that correct?
That is correct.
For the record, I am Jerome Helmer. I've been appointed as the hearing officer, presiding officer in this matter by the chair of this commission, and will now call this matter to order. This is the matter of Mark Skoglin, Executive Director, Kansas Governmental Ethics Commission, is complainant versus Joshua E. White, candidate for County Commissioner. It is complaint number 7 6:09, and Ms. Caitlin, if you would announce the appearances for the record, please.
Absolutely. Caitlin Bull Stewart on behalf of the complainant, Mark Skoglund, Executive Director. Mark Skoglund, Executive Director, also appears as witness.
And as previously stated, we have no other appearances on the record on behalf of the respondent, Joshua E. White.
That is correct.
And we've had no written or other type of electronic communication from counsel or any other party attempting to represent this individual respondent.
That is correct.
And counsel, would you also summarize for the record what the complaint is in this matter?
Yes, absolutely. So Josh White was a candidate for the Neosho County Commissioner in the 2022 election cycle. This is again another simple matter of a candidate that was required to file reports and did not do so. In this instance, there are two possible violations for failure to file the July 2022 receipts and expenditures report and failure to file the October 2022 report. The filing of reports, as we've already as we've discussed many times, is absolutely critical to ensure transparency and public access to campaign finance matters. Because this is a default matter, I will try and keep this as succinct as possible. I do request that the commission simply adopt, this is not my formal ask, but that the commission simply adopt the executive director's proposed findings and conclusions for a default matter. The language is included in there to specify which applies. That incorporates the entirety of the administrative record, including the allegations of the complaint and the additional evidence offered as part of the memorandum of support of probable cause, which the commission had access to, but is not part of the public materials. Although this is a default matter, I still want to clearly establish that the commission has appropriate jurisdiction. Mr. White himself subjected himself to the subject matter jurisdiction of the commission by filing his candidate's declaration of intent and running for office, subjecting himself to the Campaign Finance Act. Mr. White is also a resident of the state of Kansas, so personal jurisdiction is proper. Additionally, service of Mr. White was proper as reflected in the proposed report and order, and it was made at his home address. And in this instance, every aspect of service of the complaint process was via sheriff's service, and Mr. White was personally served. Mr. White has had legal obligations to file under KSA 254148, and he failed to do so. The commission's burden of proof is clear and convincing, but in this default matter, and as this is just a question of law, he did not file and was required to do so. The commission should find clear and convincing evidence that a violation occurred. The commission staff engaged in its only requirement, which was to provide Mr. White with notice of failure to file his reports. Commission staff did that both times for both July and the October reports. Mr. White has still not filed anything, even today as of the hearing. With the presiding officer's permission, I would like to swear the complainant in for his testimony regarding the outstanding reports.
Thank you, counsel. Prior to that, I will again, for the record, indicate that this hearing is being conducted according to the provisions of the Kansas Administrative Procedure Act. Again, the burden of proof is affirmative findings of fact by the commission, and they will be based on clear and convincing evidence. I will consider your summary of this matter to be your opening statement unless you tell me to the contrary.
That is correct.
And with that, I would allow you to call your first witness and have that witness be sworn.
Mark Skoglund, Executive Director, I would like to call as my first witness.
All right, you do solemnly swear, sincerely and truly declare and affirm that the testimony you shall give in this matter at issue shall be the truth, whole truth, and nothing but the truth, and this you do under the pains and penalties of perjury.
I do.
You may proceed.
Please introduce yourself.
Mark Skoglund, Executive Director of the Commission.
We're going to walk through the allegations of the complaint to ensure that the same is true today. Do you understand?
Yes.
What are the allegations in count one of the complaint?
That Mr. White was required to file a July 2022 report and did not do so.
Has he filed as of today?
No.
What are the allegations of count two of the complaint?
That Mr. White was obligated to file an October 2022 report and has not done so.
And has he done so today?
No, he is not.
I have no further questions and would seek to dismiss my witness. Well,
Your witness will be retained and
Let him
dismissed at this
rest.
point. However, I understand The hearing officer would then inquire if any commissioners might have any questions of the witness and the testimony related from the witness. Hearing or seeing none, the testimony is now concluded, and again, for the record, has there been any other parties who have appeared at this time who appear to be representing either Mr. White or Mr. White himself or someone on his capacity?
No.
Very well, thank you. That the hearing officer will consider the evidentiary portion of this matter concluded and closed. At this point, we would now move to a deliberation session in this matter. There are two factors in the deliberation by the commission. The first factor would be whether or not there's sufficient record in this matter for the commission to determine the request of the complainant through counsel. And upon conclusion of that, we move to the second level, which would apply to any amount of liability, but we're limited at this point to the first question. And at that point, are there any issues or matters to be discussed by commission members regarding this matter at this time?
Appears to be a pure ministerial failure, which is supported by allegations in the testimony as well as the sworn statements within the complaint itself and attached documentation.
I agree.
Agreed.
Any further discussion? So may we have a motion?
What will be the general form of an appropriate motion?
I request that the commission find Josh White liable under the Campaign Finance Act for failure to file a July 2022 receipts and expenditure report and an October 2022 receipts and expenditures report.
Also, no.
Second.
We have a motion to second. Any further discussion on the motion? Hearing none, all in favor?
Aye.
Any opposed? Motion carries. We will now move to the penalty phase or the liability phase of this matter. And again, the request of the complainant is counsel.
Respectfully, the request in this instance is a fine amount of $5,000 with a reduction of the fine amount if Mr. White files all outstanding reports within 30 days of the order's effective date. For context, this is not the maximum fine, as the two counts in the complaint constitute the first set of violations. Therefore, each count may be assessed $5,000 for a total of $10,000. Our request is for $5,000 with the reduced fine amount in exchange for the filing of all outstanding reports and to pay the reduced amount.
I apologize if I missed it. What would the reduced amount be? It is 5,000 or would go below 5,000 if he does those?
We are requesting it can be below 5,000 up to the commission's discretion if he were to file all outstanding reports and pay the imposed amount within 30 days.
Thanks.
Further discussion?
Fine $5,000 would be very, very heavy. Just in general. And I know that these are statutory penalties and it's a 5 and a 10 and it just feels very, very heavy. I'm willing to move for a total of 2,000 with complete waiver if he files all the documentation within 30 days.
This is the county commissioner.
And
May
Counsel, inquiry.
I would also like to add that Mr. White has also accumulated $1,300 in civil penalties or late fees for failure to file and has received notice of that via personal service, sheriff's service with letters that shows his outstanding penalties, and that did not result in any compliance or communication with our office. That is the only last bit I will add.
I'm not suggesting this is relevant to the assessment of the penalty. I'm just curious, did he win or lose this race for the county commission?
He lost.
So he's not currently holding any
Correct.
office in Kansas.
That's subject to the jurisdiction of the city.
And he served as his own treasurer.
Correct.
Commissioner Berger, your motion was reduced to 2,000 if paid within 30 days?
no, 2,000 total waived entirely if everything filed within 30 days.
And pay.
Commissioner Berger, does the Further statement of council have any bearing on your motion relative to the past due amounts?
No.
So we do have a motion from Commissioner Berger. Does anyone wish to second on
I'll
that?
second it.
We have a second. Any further discussion on that matter?
Mr. Chairman, is he still liable to pay the $1,300 or so in civil penalties, even if we, I guess, waive his?
Okay,
Yeah,
for
it's not,
Caitlin.
it's not part of my motion to waive those.
Right.
So Caitlin, just to be clear, he would still be liable for that amount, separate and
Yes.
apart from any finding here.
Yes, because again, because Commissioner Berger's motion was not waiving any civil penalties that have already been assessed.
And the amount of the civil penalties was, again,
$1,300.
so in effect, Commissioner Berger's motion would be $2,000. But that goes away if he files everything within 30 days, but he would still have the 1,000.
Correct.
Correct. But the 1,000 is not a part of the motion. So that's a freestanding finding by a previous determination. So it's really not relevant to our motion today. The only motion that is before the commission is Commissioner Berger is requesting that the liability fine assessment be $2,000 and waived if compliance is made within 30 days.
Correct.
That's the only matter before the hearing officer. Any further discussion? Call for the vote. All in favor?
Aye.
Any opposed? Motion carries. The hearing officer finds at this point in time that all statutory requirements relative to notice, service, and further matters relating to procedural issues in favor of the complainant have been met at this point in time, that the commission has found that there is a violation of the Reporting Act and the campaign finance law, and further have found that the liability for same should be the assessment of a penalty of $2,000. Said payment would be waived in the event that the complainant is in full compliance with all filing requirements pursuant to the complaint of this matter. Is that a correct statement? Any commission members see that I have misstated the facts? Hearing none, I would also entertain a motion from the commission to authorize me to sign and review a order of this matter with all appropriate findings of facts and conclusion law, also that be served upon the complainant within 30 days.
So moved.
Second.
Second.
Have a motion second. Any further discussion? All in favor?
Aye.
Any opposed? The motion carries, and with that, Mr. Chair, I will turn the matter back over to you unless you wish me to proceed to the next matter.
I say let's proceed to the next matter unless there's any reason otherwise. Caitlin or Mark?
We're rolling.
Thank you, Mr. Chair. My name is Jerome Helmer. I've been appointed as the hearing officer in the matter that is entitled Mark Scoglin, Executive Director of Kansas Governmental Ethics Commission, is complainant versus Melvin Williams Jr. Respondent. It is complaint number 770. And with that, council will give us the appearances for the record, please.
Yes. Caitlin Bull Stewart on behalf of the complainant, Mark Scoglin, the executive director, and Mark Scoglin, the executive director, also appears as witness. There are no other appearances at this time.
Although we do not appear to have other parties present, again, this matter is being recorded and therefore audible answers are required. Other physical gestures would not be able to be recorded in this matter. And with that, council, I would invite a summary from you, which I will also consider as your opening statement, unless you wish to bifurcate same as to the matters on complaint number 770.
Absolutely. This is another instance, again, a cut and dry matter of a failure to file and was required to do so. Melvin Williams Jr. was a candidate for the Wyandotte County Commissioner in the 2021 election cycle, was required to file a January 2023 report and a January of 2024 report. receipts and expenditure report, and he did not do so. Again, this is a default matter. Mr. Williams did not appear at the pre-hearing conference and is not present here today, nor is any counsel on his behalf. I still want to clearly establish again, the commission has jurisdiction by filing a candidate's intent, a declaration of intent to run for office under the Campaign Finance Act. Mr. Williams subjected himself to the commission's subject matter jurisdiction, and as a resident of the state of Kansas, personal jurisdiction is proper. Service was also proper, as again was reflected in the proposed report and order. It has been via certified mail to Mr. Williams' address, as was listed on his candidate's declaration of intention filing form. I will also add that Mr. Williams is well aware of his obligations to file, as he had he's received letters from Jen Schneider, who is the local campaign finance coordinator, summarizing what is outstanding. And I believe there is more that I will hold to ask my witness about later. But essentially, the commission hasn't complied with its requirements to notify Mr. Williams of his outstanding obligations, and he has failed to comply with the Campaign Finance Act. We have sent him the failure to files that were necessary.
And again, for clarity, this hearing will be conducted according to the provisions of the Kansas Administrative Procedure Act. The applicable burden of proof is that affirmative findings of fact by the commission shall be based on clear and convincing evidence. And with that, counsel, will you prepare to present your first witness?
Yes.
And again, for the record, we've had no one enter the room on behalf of the complainant or the respondent or the respondent himself.
That's correct.
You may call your first witness.
I would like to call Mark Skoglund, Executive Director, who needs to be.
And Paige,
Yes.
if you kindly swear the witness in, please.
All right, you do solemnly swear, sincerely and truly declare and affirm that the testimony you shall give in this matter at issue shall be the truth, the whole truth, and nothing but the truth, and this you do under the pains and penalties of perjury.
I do.
You may proceed.
Thank you. Would you please introduce yourself?
Mark Skoglund, Director of the Kansas Governmental Ethics Commission.
We're going to walk through the allegations of the complaint, specifically number 770. Do you understand?
I do.
What is the first count in the complaint?
That Mr. Melvin Williams Jr. was required to file a January 2023 report as a candidate for office and did not do so. That report remains outstanding today.
What is the second count of the complaint?
That Mr. Williams Jr. was required to file a January 2024 report as a candidate for office and did not do so. That report also remains outstanding today.
So both reports are still outstanding?
Yes.
Okay, that is all the questions I have. The commissioners, I have my witness.
We had Commissioner Jackson step out briefly, but do any other commission members have inquiry of the witness?
Not of the witness, but procedurally, are the proposed findings, commission report and order, were those also sent to the respondent?
Yes,
They are within 30 days.
Thank you.
And that was part of the motion that was made, or I announced my request to be that I'd be authorized to sign and that the copy be sent to the respondent within 30 days.
I believe Commissioner Berger
My
was.
question was different, though. My
Mhm.
question was the proposed report and
I
was sent
see.
and sent to
Yes, it was. It was sent pursuant to the pre-hearing conference order. It was exchanged within the exact, I don't remember the exact deadline off the top of my head, but it was sent to Mr. Williams, both first class certified and via email, so he didn't have to wait on the postal service.
Okay, thank you.
Thank you for the clarification. That's question. Any other commissioners have an inquiry? Out of abundance of caution, I prefer to wait on Commissioner Jackson in case he does have some inquiry.
Mr. Chairman, I have a question for council. That allowed at this time?
Yes, you may.
Council, how much civil penalties has the respondent accrued in this matter?
Commissioner, if I might ask if we hold that until we determine whether or not there's a violation, that may be premature to inquire that portion of the matter.
Okay.
Thank you. Mr. Jackson. Sorry to put you on the spot.
I apologize.
We've had the opportunity to inquire of the witness of any matters from the commission's point of view. Do you have any inquiries of the witness?
Yes, sir.
Thank you. That being the circumstance, then it would appear that the matter is now ready for a motion by the commission to determine the issue, whether or not there has been a violation as alleged by the complainant in this matter. And we'll open this matter to discussion by the commissioners.
May I repeat my request
You
for ease? The request of the executive director is that that Melvin Williams Jr. be found liable under the Campaign Finance Act for failure to file a January 2023 receipts and expenditures report and a January 2024 receipts and expenditures report.
Any questions by the commission?
So moved.
We have a motion to handle the findings as requested by counsel for the complainant. Do we have a Second. We have a second. Any further discussion?
Yeah, it sounds like the ministerial acts that are supported by the testimony as well as the complaint and the attachments to them, the verified complaint.
All in favor, signify by saying aye.
Aye.
Any opposed? The motion carries. We will now move to the penalty phase of this matter. And at this point, I do believe that Commissioner Harrison does have an inquiry.
How much civil penalties has the respondent been assessed?
Mr. Williams has accumulated $1,900 in civil penalties for failure to file campaign finance reports. Additionally, as I do think is appropriate for this consideration, Mr. Williams has had a fine imposed by the commission before in complaint number 726, where he was a fine was imposed of $5,000 with a reduction to $1,000 if the fine was paid within 30 days. It was not paid. And that complaint was due to failure to file a January 2022 receipts and expenditure report.
Just to be clear, he never paid it?
Correct. So total in liabilities owed to the commission is $6,900.
Counsel, for the record, would you again tell the commissioners what the penalty phase range is in this matter?
Absolutely. In this instance, our specific request is a fine amount of $10,000 with a reduction in the amount if he files all outstanding reports, pays the lower amount within 30 days of the order's effective date. In this instance, this would be his second set of violations under the act. So the maximum fine that could be awarded would be $10,000 per count for a total of $20,000. If the commission chooses to offer the reduced fine amount, again, the executive director respectfully requests that the reduction in amount be conditioned on the filing of all outstanding reports and the payment of the reduced amount.
Discussion?
I think just conceptually, I might be in favor of slightly lower amounts, similar to what we just did with the previous case.
Agreed. I don't think that even making it higher is going to incentivize at this point.
I would move for total of 2,000, reduced entirely to zero, of the 2,000 only, if he files everything that's required within 30 days.
Second.
And there's no precondition of any prior.
No,
No,
this is
Just
standard.
for clarification, you're staying solely on the complaint before the commission at this time, and the potential penalty having nothing to do with any prior assessments or determinations by the commission in previous matters.
Agreed.
I'm sorry, Tessie, do we have a second?
Yes.
Thank you. We have a motion and a second relative to the issue of liability in this matter. Any further discussion? All in favor?
Aye.
Any opposed? The motion carries. Again, at this point in time, I would ask the commission to authorize the hearing officer of this matter at this point finds that the respondent in this matter has been determined to have violated the requirements of the Campaign Finance Act in this matter, and having been found to have violated the same, that all appropriate notices and opportunities to be heard and respond in this matter have been provided as required by law, that the respondent is complaining of this matter, is in default in this matter. As to the liability issue, the commission has determined that a fine of $2,000 will be assessed. However, that fine will be waived in the event that the respondent makes payment or legal is in compliance with all filing requirements as set forth in this complaint. If so, then that amount would be waived. The hearing officer would ask the commission for the authority to sign the reviewed and authorized journal entry of this matter, which would also be provided to the respondent within 30 days of signature.
So moved.
Second.
We have a motion second to approve, to allow the hearing officer to approve a journal entry reflecting the findings of fact, conclusions of law set forth in this record. All in favor?
Aye.
Aye.
Any opposed? The motion carries, and Mr. Chair, I believe that concludes the hearings in both of these matters, and I'll now turn the matter back to the chair. Thank you.
Thank you very much, Commissioner Helmer, for serving as the hearing officer. Your time is greatly appreciated. Returning back to the agenda, the remaining item is we have some recess sessions, and I understand that these are broken into two parts.
Mr. Chair, if I could make one comment first.
Sure.
I don't want to do this simply on my own. Basically just go out on a limb and do it myself. Would it be helpful to the commission if I did a brief multi-state survey of at least some jurisdictions to determine how they approach default fine amounts when someone has an outstanding report and does not appear for the hearing? Because I've noticed a little bit of inconsistency in fine amount in the last few hearings, which may be for a variety of factors. I think that each case is taken on its own merits. But would it be helpful to the commission to see how other states handle these and have the commission maybe consider a typical path forward in these instances?
Absolutely.
Well, and other fines that are roughly the same. When I look, if you go 100 miles an hour, that's roughly a $300 fine. And then if you don't pay it, it's only $200.
Right.
And you can't drive, but that just seems like a better deal than we're saying it's 5,000. We're missing the 300.
Yeah, I'll look around some other jurisdictions and I'll try to include that if I get it done in time for the executive director's report at the next meeting.
Yeah.
Great.
Yeah.
I'll just kind of state it. It's not relevant to me what other states or jurisdictions do. I think we stand alone.
But
Yeah.
within the state, the same, an offense here versus an offense, what's a $300 fine versus what's a $5,000? Seems like there's should be somewhat relative even within the state.
Maybe,
I
maybe
think
not.
Yeah.
I think I support your general goal though in other matters to find consistency. And I think that this was my idea to find consistency in these matters. If you have another idea to give us a path towards consistency, I would definitely be interested to hear that as well. I think that's important.
I think consistency with regard to finding violations and the penalties that are attached is a dangerous step to take after an adjudication, because that assumes that everything is treated the same. And that's my concern there. We're talking about consistency of waiving. That's a separate issue. And that people don't come in with just the feeling and the vibe of just a general, well, people feel in a good mood today or generous today. And that's I think those are totally different.
Okay.
I think two things away on my mind is, I called it harm last time, but how many people were harmed? Is it a statewide? Or is it a county of 2,000? And then how much money was involved? We had $49 versus you have $100,000. So those two factors weigh on my mind anyway.
And those are the two that I've written down, though I did note that the amount raised is if they didn't file reports.
Yeah.
But yes, those are the two things.
But that only factors the fine. They're still guilty, they're guilty, so.
Usually, a lot of times failure to files in these cases happen after their campaign ends. They lose the primary and they just don't file reports ever again, for example. Yeah. So, okay,
I
great.
wouldn't necessarily say we should copy other jurisdictions, but personally, I would at least find it informative.
Yeah, look at it.
Yeah.
Yeah, and I agree. The goal is definitely not to do exactly what anyone else does.
Right.
It's just a matter of,
Will make sense.
I don't want us to be substantially more punitive than anyone else is, or substantially less punitive than anyone else is. But again, these cases are all taken on their own facts, and I agree that Kansas also is its own state and can do its own actions. Right.
We have,
We don't have a sentencing guideline.
That's where my brain's going.
yeah. I have 3:09 right now. How much time do we need for recess session 1?
This is the first one was with
5
that,
minutes.
right? Yeah, it's very
5
fast.
minutes. Let's set it for 3:15. Commissioner Glenn, if you could do us the honors of reading recess motion 1.
That's what I started
The one
before.
that one with-
Yes.
I can finish it now. I move that the commission recess this open meeting with Executive Director Mark Skoglund, the Office Manager Paige Quintana Paget, and General Counsel Caitlin Bull Stewart, and Conflict Counsel Jesse Burris present to discuss matters related to confidential investigations pursuant to KSA 25-4165 and KSA 25-4161, and for good causes provided by KAR 19-6-2. Justification for recess is so the commission can exercise quasi judicial functions and deliberating matters related to said confidential investigations as contemplated by KSA 75-4318 G1. The open meeting shall be resumed here at 3:16.
Yes.
Yes.
Do I have a second?
Second.
Has been seconded. Any additional discussion? All in favor of the motion to adjourn to recess session signify by saying aye.
Aye.
All opposed say nay. The motion passes.
Okay, our live stream is back.
We're live.
Okay, the next item is a second recess session. I have 3:16 right now.
Should we go ahead and vote on that last
We
one?
need to be an open session vote on that.
Yes. So why don't we,
Sure.
Just, I think it'd be easier just to do it. Yeah.
Do the vote.
Yeah.
Whatever your preference is.
Okay, do any commissioners wish to make a motion?
yes.
I would move that in complaint number 782 and in complaint number 783, that the commission finds sufficiency.
Thank you,
Second.
Commissioner Helmer. The motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to find sufficiency in complaints 782 and 783 signify by saying aye.
Aye.
All opposed say nay.
It's 783 too,
Yes, both.
because I think there's problems with 783. What do? It's too late.
Well, we said all opposed say aye, all opposed say nay.
aye.
I'll say nay on
Right, you
on
can-
783.
783.
Noted. The motion is passed. I have 3:18 at this moment. How much time do we need for our next recess session?
You've all seen the materials.
20 minutes, I think. Unless y'all think less.
So you all know more about how long to take
Yeah,
it.
let's say 30.
Yeah.
Yeah, just some 6 months.
Yeah, let's say 3:48. Commissioner Glenn, if you could do us the honors again.
Does session 2 work the same as session 1?
No.
No.
Oh, I don't.
Oh, that's the correct one. It's recess session 2.
Yeah, there's no numbers. Okay, it should work. Okay. So I move the commission recess this open meeting with Executive Director Mark Skoglund.
Oh. Yeah, wait,
Just conflict counsel.
Jesse's gotcha.
Oh, that's what's, sorry.
Thank
You're
you,
good.
Jesse.
There's only 300 motions. It's fine.
I move that the commission recess this open meeting with conflict counsel Jesse Burris present to discuss matters related to the confidential investigations pursuant to KSA 25-4165 and KSA 25-4161, and for good cause is provided by KAR 19-6-2. Justification for recess is so the commission can exercise quasi judicial functions when deliberating matters related to said confidential investigations as contemplated by KSA 75-438 G1. The open meeting shall resume here at 3:48. Did I hear? 3:48
Yes.
PM.
Yes. Yeah, do I have a second?
Second.
Motion has been seconded. Any additional discussion? All in favor of approving the motion to enter into recess session signify by saying aye.
Aye.
410-foot shot, buried the back with, yeah. Oh, I did.
Let us know.
Especially my grandson played ball, he's 7, and the fences at this field there, on mark 200, that looks like a long way, and then it asked, oh, 410.
All right, we are live.
Okay, Commissioner Glenn, I believe you have a motion that you would like to make.
I move that the commission recess this open meeting with conflict counsel Jesse Burris present to discuss matters related to confidential investigations pursuant to KSA 254165 and KSA 254161, and for good causes provided by KER 1962. Justification for recess is so the commission can exercise quasi judicial functions when deliberating matters related to said confidential investigations as contemplated by KSA 754318 G1. The open meeting shall resume here at, is it 4 o'clock?
4
Say
o'clock.
4 o'clock.
4 or 5?
4 or 5.
Is that right?
4 or 5?
Yes.
Or where do I go?
You choose.
4 or 5, sorry. We always seem to run long. I paid my meter through that.
Okay, do I have a second?
Just kidding.
I'll second.
Thank you, Commissioner Harrison. Any additional discussion? Hearing none, all in favor of approving the motion to enter into recess session, signify by saying aye.
Restart that.
And you know,
Then they'll want time alone.
only in time since I got a person, is just the happiest, friendliest guy.
Then they'll want time. Your kids are older.
Do you want this guy?
You're
Somebody pass this, do I just leave him here?
Yeah, just leave them there. We'll shred them.
I don't know what they are.
But I try not to eat it.
They will be memorialized in the minutes and then shredded or
Okay.
thrown away.
Eat it.
Okay, we are live.
Okay, we are live. We have returned to open session. Commissioner Berger, I believe you have some motions to make. Do you want to begin?
Yes, as the unofficial scrivener, I would move with regard to complaint number 781, that it be dismissed. Mr. Harrison, Commissioner Harrison?
I hereby recuse myself from consideration of complaint 781.
Okay, is the motion, do I have a second?
Second.
Motion has been seconded. Any additional discussion? All in favor of approving the motion to dismiss complaint 781, signify by saying aye. All opposed say nay. The motion passes.
That we move, I hereby move that we dismiss complaints 776, 780, 772, 773, 753, 754.
Noted. Do I have a second?
Second.
Any additional discussion? All in favor of approving the motion to dismiss those matters, signify by saying aye.
Aye.
All opposed say nay. The motion passes.
I'll move that we find probable cause for complaint 771.
Do I have a second? Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to find probable cause in complaint 771, signify by saying aye.
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 All opposed say nay. The motion passes.
And with regard to complaint 750, move to dismiss counts 1 through 36, 40 and 41.
Can you slow down a little? Please.
Yep, dismiss 1 through 36, 40 and 41, and find probable cause for counts 37 through 39.
We'll let that be its own motion. Do I have a second?
Second.
Any additional discussion? All in favor of approving the motion to find probable cause with respect to complaints 37, 38, and 39 in complaints 750, counts 37, 38, and 39 in complaint 750, signify by saying aye.
Aye.
All opposed, say nay. The motion passes.
That also include the dismissal of counts 1 through 36, 40, and 41. Is that part of it?
Yes. Yes. Um,
And there are no other motions.
okay, so we will note that Commissioner Jackson has volunteered to serve as hearing officer for any hearing stemming from complaints 750 and 771. Are there any other items to discuss? There are not. Returning to the agenda, our next meeting, it will take place in 4 weeks on July 24th. There are no other items to discuss. We'll take a motion to adjourn.
So moved.
Do I have a second? Motion has been seconded. Any additional discussion? All in favor of approving the motion to adjourn signify by saying aye.
Aye.
All opposed, say nay. The motion passes. Thank you, commissioners and staff, for your attendance today. Everyone's time is greatly appreciated. Thank you for all that you do.